Okay, we're now moving on to part two of Note 11, and we are going to spend some time talking about unions. A union is an organization which seeks to collectively bargain for a group of employees in a particular business or a particular industry. Collective bargaining is the idea that if employees approach their employer as a group, they will have more power and more ability to obtain concessions from the employer than they would be able to have by individually seeking better wages, better hours, better working conditions. Um, the idea of unions grew up first in Europe in the mid 1800s, came to the United States in the early 1900s, and they were bitterly opposed by the large corporations that were the major employers in industry and in agriculture and in commerce at the time. The federal government and the state governments were fairly unsympathetic to unions. The courts also were unsympathetic and took the position that each individual employee maintained a separate labor contract and agreement with the employer, and that there shouldn't be any intermediary coming between that. However, as we rolled again into the Great Depression and the entire economy and labor market had collapsed, it was in complete disarray. Franklin Roosevelt was able to use this time to pass legislation that would benefit the unions and make it easier for unions to become established, to stand up against employers, and to negotiate contracts on the behalf of groups of employees. Um, One of the things that the New Deal legislation did was create something called the National Labor Relations Board, or the NLRB, and their specific role is to deal with unions and employers and to ensure that the unions are given a fair chance to organize and to be accepted by the employers. Right? In 1932, Congress passed something called the Norris-LaGuardia Act, which limited the power of federal courts, took jurisdiction away from the federal courts in terms of stopping strikes or in terms of intervening in union employer work situations. All right, now, some definitions that we need to know. A closed shop is a company where you must be in the union prior to seeking employment, and you cannot be employed unless you're already a member of the union. There are a number of unions that exist not for specific companies, but for certain types of employment, such as carpenters, such as auto workers, such as healthcare workers, hotel workers, restaurant workers, college professors, and even associate professors. We have unions. So in a closed shop, you must have become a member of the union, and certainly in the trades, when we deal with carpenters and electricians and plumbers, the unions have their own internship programs. They have their own rules and regulations that determine when you become a member of the union, and any closed shop cannot hire you unless you have that union card in your pocket. A union shop means you don't have to be in the union prior to being hired, but that you have to join the union upon being hired, and that you have to participate, and that usually means paying union dues whether you want to or not. Now, many states in recent years, maybe the last 20 years, have passed what are called right to work laws. And in these laws, the employees have the right to refuse to participate in a union. So even if you are technically in a union shop, in a state where there are right to work laws, of which Rhode Island is not one of them, you can refuse to participate in the union, you can refuse to pay dues, you can refuse to pay a member. It may not make you very popular with your fellow employees, but you at least have the right to do that. Now, one of the great issues was, how can we form a union in a particular place? How can we bring a union into a particular industry or business or establishment? It was something that was incredibly viciously fought by employers during the 1920s and early 1930s. They would do anything and everything they could to prevent unions from coming in. even to the point of there being violence to union representatives, union organizers disappearing or being killed or being beaten. So, or people who were attempting to join a union, if it was discovered, you were fired and again possibly beaten or even killed. Very, very nasty, difficult things. So once the federal government moved into this area of law, they began to put down very severe regulations to make sure that employees could have a voice and could be able to organize if they chose. Today, if a union representative can begin a campaign to sign up workers in a non-union shop, and there can be no retaliation for this. So if it's one of the employees who's seeking to organize their fellow employees, they cannot be retaliated against by the employer. The employer has to let them discuss this. They have to let them try and get other members. If they can get 50% of the employees to sign up and say, we are desiring a union, we want to look into this, then the employer is forced to allow a vote. And if a majority of the employees vote that they want a union, then the employer must submit to collective bargaining, and now the union becomes the only party that can negotiate a contract between all of the workers and the employee. The union becomes is granted the exclusive right to represent the employee interests. The National Labor Relations Board has oversight over elections and bargaining when it comes to unions. They have established a number of things to keep employers from getting nasty in this process. And some of the practices that they have prohibited are interference with organizing of a union, the employer dominating financially or controlling the union by putting employer representatives in there, or people who, employees that will be working to bring about the employer's interests, not the interests of their fellow employees. They cannot discriminate in hiring, promotion, seniority affecting union workers. They cannot engage in reprisals, and they cannot refuse to bargain or refuse to bargain in good faith. All of these things are actionable, and if an employer is cited by the NLRB for participating in one of them, they can be heavily fined, and the courts will enter injunctions for them to stop these activities. Another law that was passed during the Great Depression is the LMRDA, which is the Labor Management Reporting Disclosure Act. Under this, the basically it gave more control to the unions as against the employers, so that the unions could make sure that they are adequately representing their employees and adequately representing their people, but at the same time, there are requirements that were now put on the unions. Closed shops were made illegal in many situations. Union shops were still okay, but the unions were now brought under the jurisdiction of the National Labor Relations Board. They could not engage in something called feather bedding. And feather bedding is the idea where the union begins demanding the adding of positions, many times ones that the employer doesn't want or doesn't need, but because the union is forcing the employer's hand, the employer feels they have to go along. So that was made illegal. The unions were required to have regular elections by secret ballots. They prohibited any convicted felons from becoming officers. Union property had to be placed in trust accounts and be accounted for. And the union meetings, the union members had the right to attend meetings and to vote. And there was something called a no-Hart-Cargo agreement, which means that the unions could not force the employer to only buy from other union shops. They could not control how the employer would get their goods or services from other people. Again, trying to come with here's the federal government trying to come to some balance between two competing forces that were desperately bitter against each other for many, many years, and even today still are in many situations. Um, at present, the NLRB can force an election when as few as 30% of employees have signed authorization cards. So at 50%, the election becomes automatic, but if as many as 30% sign, the NLRB has a right to tell the employer you must hold an election. Now, collective bargaining definition. It's having one person negotiate and bargain for contracts on behalf of a group of people. Under the federal laws now, once a union has been established, the union is the collective bargainer. They speak for everyone who works in that facility. All right? Now, again, all bargaining must be done in good faith. There can be no rejection of proposals from either side without counter offers or without comments. There can be no running campaigns by the employer to undermine the union, no changes in wages during a collective bargaining period. You can't shift employees' positions back and forth during the collective bargaining period to try and influence them or persuade them to vote against the union or to stop the union from representing the employees vigorously. And the persons engaging in the bargaining on both sides must have the actual authority to make the deal right there at the table. So none of this, well, that's a very good idea, but I have to take it back to my boss, or that's a very good idea, I have to take it back to the members. The parties have to come to the table with the authority to enter into an agreement. A strike is when union workers refuse to work because of either working conditions or violations of their contract or failure to reach a contract. Under federal law, the union workers have the right to strike, they have the right to picket, they have the right to protest, all under the First Amendment. Right? Violence, mass picketing, sit-down strikes, boycotts, wildcat strikes, which means striking without union approval, are illegal and can be enjoined by the courts. The employer can hire replacement workers for the term of the strike. They can bring in people to fill the positions that the union people have left when they are striking. Normally, when the strike is over, anyone who was a striking employee under the NLRB rules, they must be taken back. But there are certain situations with highly skilled employees or employees for very critical positions where that may not be true. Now, there is something called a lockout, which there was some question as to whether this was legal or not, could it be done or not. A lockout is when the employer refuses to allow the workers to come back to work. Under Ronald Reagan in the 1980s, the air traffic controllers formed a union, and they were all federal employees, formed a union, and they went on strike. Of course, that brought air travel in the country to a grinding halt. President Reagan gave them an ultimatum and said that they had to go back to work by a certain date, and if they didn't, he would fire them all and bring in new people. The union did not believe he would do that. They did not believe the courts would uphold him in doing that. They called his bluff, much to their dismay, because the courts refused to intervene. Ronald Reagan fired all of the striking workers and hired people to replace them, and many of the people never worked as air traffic controllers again. Major League Baseball had a lockout of players at one point when the players' union and the employers, the team owners, were in a go-around over contracts for the players. So an employer does have some power to fire people or to basically lock people out if they're striking and refuse to turn to work. Now, when it comes to public service positions, most states have laws that present necessary employees, such as fire, police, teachers, rescue workers, EMTs, from striking. Very often, they will try and call a strike, and most state and federal jobs are under union organization at this point in time. So the unions do exist for these folks. But if they refuse to go back to work, they can be held in contempt and they can be jailed for contempt of court. The federal laws protecting workers apply to state governments only limitedly because, again, the 11th Amendment comes into play, and while the unions do have some protections, it's not as great a protection as they have with a private employer. There's some freedom given to the states to be out from under federal control and to control their own situations. There has been much discussion recently about whistleblowers. A whistleblower is an employee who informs about an illicit or illegal activity going on within the organization where they work. There is a Whistleblower Protection Act on the federal level to protect federal employees, and that act says that all U.S. federal agencies must have rules providing protection for whistleblowers, and that someone who discloses illegal or corrupt or wasteful government activity of their bosses or fellow workers cannot be fired and they cannot be retaliated against. Many states have passed similar laws that protect people working at the state level and even in private industries to a certain extent. All right. Going even one step further, we haven't really talked yet. We will get into it a little bit, a couple of notes down the road, talking about the Securities and Exchange Commission and the control of corporations and the regulations, particularly for publicly traded corporations that sell their shares of stock on the open market. Responding to some great corruption that went on during the initial tech boom, Congress passed something called the Sarbanes-Oxley, named after two of the senators who proposed it, Act of 2002, and it placed all kinds of controls on corporations, basically to make them more transparent, to make their records more open and available, to make sure they kept adequate records, all for the purpose of ensuring that the public would know what's going on in corporations and they wouldn't be buying stocks and shares or bonds, not knowing the true status of the corporation or the true status of what was going on. And within Sarbanes-Oxley, the statute gives certain whistleblower protections to employees that know that information is not being revealed. And it goes so far that for certain people, particularly people who are in management, on boards of directors, or are corporate officers, the failure to disclose wrongful or fraudulent or illegal activities actually carries a criminal offense now under Sarbanes-Oxley. So just know that that's out there, that not only is there some whistleblower protection, but if you're working for a publicly traded corporation and you're up in the upper echelons, there's actually criminal penalties that could apply if you are not bringing to the shareholders, bringing to the directors or parties that can take care of it, illegal, immoral, fraudulent type situations. All right, that ends our discussion of Note 17.